So good morning again, everyone. My name is Chris Milazzo. I'm an attorney. I'm the business litigator of the group, and I focus my practice really on general business litigation. Disputes that come up kind of every day between businesses or between individuals and businesses, and hopefully take them to a conclusion that's beneficial to my client. When I was thinking about what to do today, I figured, let me talk about some contractual terms that are basically in every contract that you're going to enter into. And we're all here, or most of us here, are small business owners. We're entering into contracts all the time with service providers, with vendors, with suppliers. And there's these terms that are kind of buried at the end of a contract, or maybe on the reverse side of a pre-printed contract, that have great consequences. And we call them boilerplate terms. There'll be people, when you're sitting and looking at them, say, don't even read them, they're just standard terms. It's not the case. And unfortunately, you know, I think I could count, in the 25 years I've been practicing, I think I could count on one hand the amount of times the clients come to me before signing some sort of a service agreement where he's bound for a year or 2 years, and come to me and said, can you take a look at this before I do this? So I thought I'd go over just a few of the terms that are in most of these contracts and that can cause some problems. So the first one, and if you look at the handout, is what's called an automatic renewal provision. And these are provisions that after a set initial term will renew automatically for another term. So for example, the example here is a 3-year initial term, and it renews automatically for 1-year periods after that. And these are very, very dangerous provisions, especially this one, right? It's 3 years later. You may not remember to tell the vendor or the supplier, whoever's on the other side of this contract, I don't want to renew. And all these provisions have, or most of them anyway, have very specific notice requirements to actually terminate the contract. Like this one that we have here requires you to terminate it 3 months before the end of the term. So if you don't do that, and you try to terminate a week before, too late. You're on the hook for a whole nother year, and you could be paying a set monthly fee for a whole nother year. I will give an example. I represented a client that was hired an executive search firm. My client was growing like crazy, so they agreed to an $18,000 a month monthly fee, 1-year term. At the end of that term, things weren't going so great for my client. My client told them, you know, we're going to put this on hold. We're not going to go forward another year. Well, the notice required written notice. So after a year, my client gets sued for $180,000 in monthly fees. Now, we were able to get out of it. It was a poorly written clause, but that's the danger. So the best thing to do is negotiate your way out of this, try to get it excluded. If you can't, you really have to make sure that you put some sort of tickler on your calendar. I have to give a notice at this time. Now, New York State also does provide somewhat of a safety net. New York State will require in a service contract, which is pretty broadly defined, that the vendor notify you between 15 and 30 days before your time to terminate comes up. But, you know, if open question is, if the contract provides for the law of another state, does that apply? So best way is to negotiate it out. Otherwise, make sure you're set with something on your calendar to make sure you notify in the way the contract says that you're terminating. Another typical provision in these clauses, especially if you're dealing with, you know, internet providers or IT companies that are not really within New York State, is what's called a forum selection clause. And what that's going to do is that any action, like let's say they breach, if you want to bring an action, they're designating the law of another state, the place of another state that you have to bring that action. This example here requires in Florida. So if the person you hired breached the contract, if you wanted to sue them, now you're stuck trying to go to Florida. That's another thing you should negotiate it out or put in that you can sue in New York as well, because that's going to cost you a lot of money. You're going to have to hire a Florida attorney. You may not know. You're going to have to fly to Florida for any trial or for any hearing. a lot of expense added to that. The third type of provision that's in a lot of these contracts is what's called a limitation on liability. And what that's going to do is it's going to limit the types of damages that you can recover if the vendor or service provider breaches. And there's a lot of consequences to somebody like is providing, let's say, providing trees for the landscape architect, right? If they don't provide the trees, what happens? You may lose the client. Well, this provision would bar any claim for damages for that. Now, you might be able to sue for any deposit you gave or sue for the difference in the amount you had to pay extra for the trees, but you would be barred from losing or from suing to recover the value of the lost clients you suffered as a result of their breach. And there is some limitations on that, in that if it's a willful breach or it's grossly negligent, you can sue. You can't exculpate your liability for that. But otherwise, the courts enforce these, and they enforce them regularly in business-to-business contracts. We're not dealing with business-to-consumer contracts. It's a different story. But a business-to-business contract, the courts regularly enforce these. And the other thing that this provision provides, if you look at it, is your damages are limited to the amount you paid. This is pulled from an Amazon contract. They're limited to the amount you actually paid for, I think it's the 6 months prior to the breach. So let's say you only paid $1,000 for the 6 months prior, but they caused damages in excess of $50,000. Well, you're stuck with that $1,000 limit. And that's a very typical contract, Jay, in real estate, where the home inspectors, they have these limitations of liability. So you pay $1,000 for a home inspection. They miss a water problem in the basement that causes you $100,000 to fix. Well, you're limited to $1,000. And I've seen the courts, the appellate divisions, regularly enforce them. And the last provision that's buried in a lot of these contracts, which is one of my pet peeves and something I'm very much against, is an arbitration provision. So in an arbitration provision, you're agreeing to have your disputes adjudicated by some independent third party that's not the court. You lose your rights to appeal, you lose your rights to a jury trial, and the expense of this, which is not in here, is incredible. What you're really doing is you're paying a judge or a panel of 3 judges to adjudicate your dispute. This can cost, I had a case where our portion of the fees was over $100,000. So rather than go to court, where you wouldn't be paying that, you'd have a court, taxes pay for the court to adjudicate your disputes. Here you're paying for it. It's a hidden cost. And a lot of times, frankly, it's put in the contracts to really dissuade somebody from bringing an action, because they know the filing fees are in the thousands of dollars, depending on how much you're suing for, and then the costs going forward are just much, much more than it would be in regular litigation. And this will, a lot of times, make a person decide it's just not worth it to bring this dispute to an arbitrator. So these are some of the provisions, and like I said, if you can negotiate some of these out, negotiate them out. But I think the big thing is you need to go into a contractual relationship at least knowing what to look for, at least knowing what's going to happen or what your liabilities or potential problems are. So at least you'll go in with eyes wide open, rather than getting surprised like my client was a year later when he didn't give notice the correct way and got hit with a $180,000 lawsuit. So thank you. Oh, sure. I thought you were giving me like a 2-minute.
No. Let me raise my hand.
Oh.
So you introduced yourself as a commercial litigator. You handle business transaction disputes and so on and so forth, business relationship disputes. But can someone come to you and consult with you with regard to a contract that they may have been handed or asked to address so that they can avoid litigation down the road? Are you
Absolutely, absolutely. So I do, my practice is not only just the litigation, but also the pre-litigation, trying to avoid it down the road. And a lot of times the best way of avoiding it is, dealing with it up front when you're entering into the contract. All right, well, thank you very much. Oh, yeah. Oh, it's good.
So I've had to deal with contracts with some of my clients, and it goes to Jay's question. So, I mean, I think I can read a contract, but obviously I can't read a contract, right? So you agree that if I had a contract, I could say, could you look this over, Chris? This is a situation I'm under.
Absolutely. I'm happy, and I'm happy to look over a contract and at least, help you negotiate it, or if it doesn't get negotiated, just tell you at least what you're going into.
Right.
Well, one more, Jonathan.
Just really quickly, everyone, I'm potentially entering a new agreement with an existing company, and Chris and I met, and we called it as a one-to-one, but the whole idea is I asked Chris, what would you do? What questions would you ask? If you were in my exact situation, what would you? And he said, well, have you asked this? Have you thought about this? What happens if this? And I took a long list of notes and presented it back to that person. They said, these are all really great questions. Let's think about that more in depth. So to your point, it was incredibly helpful, so thank you.
Thanks. But yeah, anybody who has a contract or something they want to take a look at before going into it, like I said, some of these contracts, they're a year or 2-year initial term. I mean, you're entering into a relationship that could cost a lot of money over a significant period of time, and to go in knowing what you're getting into, I think is very important. Yeah.
A leading question, just
Sure.
so you have this on tape. So you also work with businesses who the partnership doesn't work out?
Oh, yes. I also will deal with, so I will deal with partnership disputes, shareholder disputes, things where, or a joint venture where things don't work out, and there's a dispute amongst them. Thank you. Thanks.